We agree that the Constitution may not have captured the mind of the framers of the Constitution.
Yes.
And the framers of the Constitution may not have captured the minds of the
people.
Yes. What is the role of legislation, regulation, and policy then?
The Parliament, the National Assembly, is an organ which serves the interests of the people. And we would expect that being representative of the people in the constituencies, and they have the legislative mandate, they would, in developing the laws that they make in Parliament, be representatives of the people. And that therefore, they may, and the Constitution always leaves room for that when it says that Parliament may enact legislation to implement a particular constitutional provision. So Parliament and legislation will come in to fill in the gaps. But there will be situations where
So are we then saying that
yes,
after Parliament has filled the gaps,
yes,
the judiciary will still fill other gaps?
that has been a question, a late question, which I would answer myself that the judiciary has no authority to make laws to fill a gap which has been left by Parliament. It ought to be the work of Parliament to, in its legislative mandate, do that.
Thank you. It's all right. Thank you.
Versus Beasley.
Yes.
It's a famous decision where Lord Denning stated as follows: fraud unravels everything. The court is careful not to find fraud unless it is distinctly pleaded and proved. But once it is proved, it vitiates judgments, contracts, and all transactions whatsoever. Now you have a case
Yes.
Whereby you've had the witnesses, say it's a commercial case, you've had witnesses for both the plaintiff and the defendant, and you've analyzed the evidence, and the end of it, you found in favor, say, on behalf of the plaintiff.
Yes.
And you've delivered judgment, and a decree has been extracted. Then, soon thereafter, maybe 6 months after, the defendant discovers that there was some fraud that had been committed on the face of the court in terms of the proceedings, either through a gross misrepresentation, or there was a fact that was said that was untrue.
Yes.
And now, how would this defendant get a remedy in view of the fact that fraud had been committed to obtain that judgment? What would be the process? Would it be through a review? I mean, how would such a defendant find a remedy? It's number one.
Yes.
And as you're answering that, there'll be competing principles in terms of finality to litigation, and also that fraud unravels everything. And remember, you've had the evidence, you've had the witnesses. In fact, it's at the point probably where the execution has commenced.
Yes.
Yes.
The principle that fraud invalidates
Yes.
all proceedings
Yes.
should be given effect to allow the court to reopen the proceeding at that point and deal with the matter on the basis of the fraud which has been established.
Okay.
because if that did not happen, then it would mean that a party obtains judgment by fraud, and the court would have helped him to defraud the other side.
Okay.
So that where case of fraud is established, that judgment should be set aside in the interest of justice.
So how would it be set aside in view of the fact that it has been proved and pleaded? Is it through a separate course of action that challenges that, or does a party go to the same cause and seek to reopen it?
I would say that he ought to come by way of review to say that there is I do not know the facts, whether it will be an error on the face of the record, something that you can see.
No, it cannot be an error on the face of the record, yes, because it's fraud.
Yes, but there is the last limb,
yes,
about for other sufficient reason.
Yes.
And I think the discovery of fraud,
yes,
would be more a sufficient reason than any other I can think about.
Okay.
Yes. And the issue of finality,
yes,
and matters of the court being ex officio would not, in this case, be held to apply because of the gravity that we give to the issue of fraud.
Okay.
Yes.
The other issue that I want to raise with you is in a case whereby, now this is a constitutional issue, and I know, yes, you're very familiar on this territory,
yes,
whereby you have parents who are homeschooling children,
yes,
and homeschooling has not been recognized as one of the methods of educating children through the Basic Education Act.
yes,
and their parents support, maybe because of their religious inclination or because of their whatever their inclination, decide to homeschool their children and find a problem in terms of transiting, for instance, from primary school to high school because of the provisions of the Basic Education Act.
yes,
And they come to you and say that they've been homeschooling the children. The Basic Education Act does not recognize that,
yes,
room for that.
Mm-hmm.
The children have a right to basic education,
yes,
which they are conducting as parents,
yes,
and the Ministry of Education ought to be compelled to recognize that method of educating them. What will be your view about that?
There are many competing interests there because
Yes.
The right of a child to education, the right to the best welfare of the
Yes.
child,
Yes.
and now the regulations or legislation by government in the Basic Education Act, which is to apply to all system of education in Kenya. And the court will be asked to determine
Yes.
whether this child who has done, say, all the way up to the basic primary education and he should be going to secondary, is to be dropped off the education system,
Yes.
and not be allowed to access the secondary school,
Yes.
or the education that she has gone through recognized because she went through a different system.
Yes.
I think a court which is mandated to give effect or to implement human rights ought to stay with the provision of, in the best welfare of the children, the right to education which they have chosen and they have been provided for by their parents,
Okay.
rather than shutting away from the mainstream education system.
Okay.
Yes.
Thank you, Judge. Thank you, CJ. That's all from me.
Thank you so much, Honorable CJ, and Judge, once again, welcome.
Thank you.
Let's take a walk to Article 50, Article 6 of the Constitution. This one provides for instances where convicted persons can petition for a new trial.
Yes.
Now, in what instances can such a person file petition for a new trial?
Yeah, this is an exception to the common rule about finality of decisions in criminal cases. And the idea here is that the applicant should have exhausted, should have gone through all the steps of criminal trials, but it is given a room where there is discovery of new evidence which was not available at the time of the trial and appellate process, but which affects the outcome of the trial. It is pegged on the discovery of new evidence.
Okay, so if I get you right,
Yes.
you're saying two conditions. One, the appellate process must have been exhausted.
Yes, yes,
Or two, when there are new evidence.
yes.
Okay. Now, when you are dealing with the second limb, that is the new and compelling evidence, what parameters do you look at as a judge to satisfy yourself that this qualifies to be new and compelling evidence?
Yes, I would have to look at a level of proof which establishes prima facie case that the outcome of this case would have been different had this evidence been availed. That it would have affected, as we say in the election terminology, it would have affected the outcome of the case. So if that threshold is reached, that on the basis of this new evidence, the outcome of the case would have been different, then the case should be reopened and determined.
Right. And what about the availability of that evidence during the trial? Is it a factor you consider, whether that evidence was available at trial?
Yes, I think in the interest of justice, so that we have balanced prosecutorial proceedings, if this evidence was available at trial and it was not brought forward, then there must be a consequence on that. Yes.
Okay, thank you so much.
Thank you.
That's all for now, Mr. Chair.
Thank you. The judiciary has embraced alternative justice systems and ADR.
Yes.
Can you tell us which cases are appropriate for what kind of, give me an example of a case that's appropriate, what kind of case are appropriate for ADR and which ones are not appropriate?
In the civil process, and I have ADR as the umbrella relief of arbitration, mediation, reconciliation. Under the civil process, cases of personal nature, where in succession, for example, matrimonial, if it is possible, although the emotions in those cases hardly allow for any form of alternative dispute other than court mandated. It would be cases of personal nature that should go to ADR. But of course, in commercial disputes where we have clauses for arbitration, these ones would have to go to arbitration by virtue of the contractual agreement between the parties. You mentioned AJS, the Alternative Justice System, And on the criminal side of things, we have allowed also, I could also use the personal nature of claims like common assaults, issues arising from forcible detainer of property and matters like those. But we have an exclusion in matters of injury to person, particularly by way of defilements and other sexual offenses. So even when AGIS has been mooted and promoted, the parties and the members of the public are always guided against use of any out-of-court settlements in sexual offenses.
What about in election disputes? Is it possible to use ADR for that?
The election disputes, in fact, have had informal ADR because we have seen cases where the petitioner comes, sometimes almost at the day of hearing, and withdraws the petition. For whatever, however it has been done, he has thought of abandoning the petition challenging the election of the candidate who was. This happens where the person who lost has found other avenues of income, and therefore is happy to wait for the next turn. But I think there was an innovation where, under the election rules, because of that kind of out-of-court settlement, the law allows another person to come over and take over the petition, so that you don't agree out there to compromise the justice of the election matter and leave the matter unaddressed. The rules allow for takeover of an election petition.
Thank you very much, Judge.
Thank you, Chair. Good morning once again, Judge.
Good morning, Commissioner.
When the Attorney General asked you a question, you said you will not promote political activism. It is argued that our Constitution is an activist and transformative document, and courts are expected to proactively interpret it in order to enforce and realize our values and social justice goals. What do you have to say about that?
What I meant by that is that, and I think I will draw examples from recent decisions of the court, that the court is not expected to fill in a gap and say, this is what Parliament should do. This is an example of the topical issue of the life sentence and term of years, where the Supreme Court has said that the Court of Appeal has no right to say that the life sentence is equal to or could well be interpreted to mean a term of years, 40 or 30 years, as has happened in some cases.
Okay, so is there a difference then between judicial activism and judicial restraint?
Judicial restraint is when, in my understanding, the court says that this matter should be dealt by Parliament, for example, because it is an organ mandated to deal with this. And we say that the doctrine of separation of powers is one for mutual respect of the respective spheres of the organs of government, so that the court will not do what ought to be done or what has been mandated to be done under the Constitution by another body.
And activism? Judicial activism?
Judicial activism is where, being the court judge, for example, being of a certain mindset, uses my proceedings and my determinations to further my beliefs. If I believed that, I want to give an example. If I believed that,
Okay, we can just leave it at that.
Yes.
Because I'm focusing on the sample writing.
yes,
So you did submit your 5 sample writings, 3 constitutional petitions, those were decisions, and 1 RTA appeal and a conference paper. They demonstrate analytical depth and right-centered reasoning. You are able to apply the law and the fact clearly. You frame issues precisely, and you are able to reach coherent conclusions with proper use of authorities. So I commend you for that.
thank
And
you.
the
Commissioner.
conference paper you did present on electronic payments, cryptocurrency, and judicial handling of financial dispute, it shows that you are aware of the new and emerging legal issues around that particular topic, and again I commend you for that.
Thank you.
I have taken note of the COVID-19 matter where you awarded 1.5 million
Yes.
to a petitioner after
Yes.
you held that his rights had been violated when the police were enforcing the COVID-19 regulations.
Yes,
I see that there is emerging inconsistency on remedies for human rights violations between courts of coordinate jurisdiction.
Yes.
So you find the High Court adapt a more restrained approach to damages, while the ELC and ELRC tend to award comparatively higher compensation for
Yes.
similar violations.
yes.
Could you maybe have anything to say about that? Because if you look at most civil and political rights violations by the high courts, the awards are usually 1.5, and if you go to employment and labor, wrongful termination, somebody can even get 8 million.
Yes,
I know Kenyans will look at it that this is the judiciary.
yes.
Yes, if you have anything to say about that.
I would say that constitutional damages are targeted to vindicating the violation. It may not be that we give an amount of money that rewards you for what has been done. It is to vindicate you for the breach of the rights, and to send a message to the person in case of horizontal violation, or to the state in vertical violation, that this breach is not. But I think under the labor court, they adopt a more actual. It's like on a reimbursement basis, that they give an award for the actual loss which has been incurred. I think that with this Court of Appeal, guidance may be given to courts, both us in the High Court and in the Labor Court, as to how to approach these issues of remedies by way of compensation for damages.
Okay. Even that applies to also the Environment and Land Court. If you look at the damages, you
Yes.
see the trend.
Yes.
The High Court seemed to be awarding less, but just something to note.
Yes.
Thank you for your responses.
Thank you.
Thank you, Chair.
Thank you, Chair. Good morning once again, Judge.
Good morning, Commissioner.
Yes, ability to perform is one of the qualities of a good judge.
Yes.
And because I believe you're a good judge, I want to
you.
imagine that you are well appraised of the your performance of your court, and also performance of the institution.
Yes.
Okay, so I just want to engage you briefly on the last SOJA report.
Yes.
The last SOJA. SOJA
Yes.
has reported it, yes. So we have certain performance indicators that
Yes.
we measure in
Yes.
our PMMU.
Yes.
One of them is case clearance rate,
Yes.
and another is backlog clearance rate.
Yes.
Could you explain to us the difference between these two?
Yes, I have interacted. In fact, I pulled out case clearance rates for the court where I'm presently serving. And for the period between January and December 2025, we have a case clearance rate of 108%. This I understand to mean that we have, in the period of the year 2025, we have dealt with all the numbers of cases filed and eaten into the backlog which we had inherited from the year 2024. Yes, 24, because of the 8% over and above the 100 that has been filed. Backlog clearance would then mean that of the cases which we have categorized as backlog, cases above 3 years, when we are able to score a clearance rate of above 100%, we shall be reducing backlog. And the computation of the number of cases captured as backlog that have been reduced would be the backlog clearance. But I'm not clear on how to calculate the backlog clearance rate.
The backlog clearance rate, you just explained that.
Apart from court clearance rate.
The case clearance rate.
Yes.
You've explained, I think, explicitly how we arrive at the backlog clearance rate. Where I'm not very clear is the case clearance rate. So when you say you're not clear how to calculate the backlog clearance rate, I'm wondering how, because that's what you've explained in depth. What maybe we are still left in the dark is how to calculate case clearance rate.
I would hazard that the case clearance rate would be the percentage of the cases determined and finalized in the period against the cases that are filed that particular period.
Correct.
Yes.
Okay. Now, the other question, you have given us the case clearance rate of your court, Kerugoya.
Yes.
Since January, you said.
Yes.
Okay. Back to the Soja report.
Yes.
In the last review, what was the overall case clearance rate for the institution, for all the levels of court?
I beg your pardon, I have not taken that.
What about for your court, High Court? Your court was doing quite well.
I only captured the
one for your specific court.
My specific court,
okay.
Not the High Court.
The one for the Court of Appeal, which is the court you aspire to join, was 77%. Of course, we understand the challenges under which the Court of Appeal is performing. It's clear that they were not able to clear more than even what they received in the period, the period under review.
Yes.
So part of the reason we are recruiting today is to address the problem of numbers.
Yes.
And I would want to hear from you, if you're successful to join the Court of Appeal, what are you going to suggest you do so that you can improve on the case clearance rate?
Yes, 77% means that you are not, you are only slightly above 2/3 of what is coming in, and you have not even touched any backlog. The backlog remains.
Yes.
And from the reports, if the backlog is as high, then the court needs to adopt strategies for reduction of the backlog. I have, in my experience, reflected on this and thought that in addition to review of rules to allow for an expedited determination of the interlocutory applications so that the matters proceed to the appeal directly, we should also have some practice direction and I would offer this to the Honorable the Chief Justice, that in 1984, the practice then, there was practice direction of number 1 of 1984, which introduced the Friday Judge Matters. Friday Judge Matters was that on Fridays, every judge of the High Court would be given a number of minor applications to deal with. And it used to be called the Friday list. If that kind of suggestion were to be made to the Court of Appeal, and instead of having a single judge deal with the urgent applications, we have all the judges on a Friday deal with the minor applications before the court on the basis of a Friday course list. Then we would be able to deal with this impediment of having to hear the applications before you go to the appeal. The Rule 52B, which I understand is a major load of the court, can also be amended so that those applications are heard by a single judge. And that would just require the amendment of the rules to allow for that. Then with the judges now being available to do the Friday matters, we will now be able to go to the appeal. There is also an invention which may be looking back in history where we have come from. Under the old constitution, we had the Section 84 of the Constitution allowing for enforcement of fundamental rights and freedoms. And we had Section 67 of the Constitution allowing for a magistrate's court to refer cases to the High Court for constitutional determination. And at the time, before the rules were made, Chief Justice Apalu had said you can use the ordinary motion or summons procedure to approach the court. But in 2002, what was called the Chunga Rules of 2002 had a provision for kind of a moratorium for the period between the reference under Section 67 to the determination. So that once a reference is filed in the High Court, status quo was held by virtue of those rules, Chunga Rules, so that you go into the hearing of the petition. These rules were amended in 2006 by the Gisero Rules. And at the time, there had been cry that no, this automatic stay is delaying rather than helping. So the Gisero Rules under Rule 23, I recall, now set the fact that now you have to apply. There is no automatic stay. You have to apply for an order for stay pending the hearing of the petition, constitutional petition. Then this is what was taken up in 2013 by Mutunga Rules. Again, it was continued the practice of having to apply. So I thought that the Rules Committee, particularly here in the Court of Appeal, may think of a rule where once a valid appeal has been filed by a valid notice with leave, then there is a rule to stay the matters as happening at the time of delivery of the judgment appealed from, to allow the parties go straight into the appeal. A form of moratorium for any action on the matter. And it is not lost that if a party is aggrieved by this automatic stay, they can come to court. But the majority of them would have had the stay granted, and we know that in about 90 days, the matter would have come to hearing when these many applications interlocutory have been removed. So I would suggest at the Court of Appeal that we consider a form of rule mandating stay, so that we remove the interlocutory appeals and we go interlocutory applications and we go into that. The other thing is...
It's okay, Judge. I'm satisfied. It's
Thank you
clear
very
you've
much.
given it a lot of thought,
Yes.
and you've made quite a number of interesting suggestions, which I
Yes.
believe the Honorable CJ has heard you.
Thank
Thank you, and I wish you well.
Thank you.
Thank you, Honorable Chair, and welcome again, Judge.
Thank you.
Is corruption in judiciary a perception, or is it real? And if it is a perception, how do we change this perception to enhance public confidence? If it is real, what steps will you take as a judge to minimize these incidences?
I think corruption in the judiciary is both perceived and actual, because you have, as a commissioner, have found various judicial officers and judges to have been involved in corruption, and you have taken appropriate action as mandated under the Constitution. But it is also a matter of perception, which is a historical injustice on the judiciary, because it is taken that the judges of Kenya judiciary are corrupt, and that all this time we have been trying to cleanse that image, even internationally, so that the perception for members of the public in Kenya and internationally needs to be disabused of the notion that the Kenya judiciary is corrupt. And that is where the perception, dealing with the perception, comes in. And I think that if the judiciary took proactive steps to educate members of the public on the system of justice, on how we deal with cases, on the process of court, that when you lose a case, it need not be that the judge must have been seen in the night. The public will be able to know that you may lose a case fairly on the basis of the law and evidence. And I must commend the judiciary with the dialogue days, what we used to call open days. I know one of them is coming on the 30th of this month, and this is a forum for engagement with members of the public, where the judiciary will be able to explain the actions that we take on the evidence that we have before us, so that the members of the public will see that we are acting in line with the law and the facts that are brought up. There is also, on the aspect of actual integrity concerns, the strict enforcement of the Judicial Code of Conduct and Ethics. This is the code which was promulgated in 2020 after many trials since 2016. The Honorable Chief Justice was in the committee that was developing it, and I was privileged to sit there. I think that strict enforcement of the code would also help, because the policy ought to be, as I think, that a judge should not be dishonest or corrupt, and a corrupt person should not be a judge. So if we have persons who are judges and are corrupt, they must be removed. I don't think there is two ways about that. So the judiciary must be active in cleansing the staff, where actual cases of corruption are determined to exist. They must be dealt with firmly and with no tolerance. I think that the members of our country, of our public, are civilized enough. They can see effort being done. They can tell that something is being done about this, and they will help. They will participate as they are mandated to do under the Constitution, and we shall, on a case by case, improve the image of the judiciary as matters corruption go.
Very well. Now, in your many years of experience, is there an instance you yourself faced an ethical dilemma, and what did you do? Would you kind also to share maybe with us and how you went about it?
I have not myself been approached by any person to deal with any matter other than appropriately in accordance with the law. But I have, but this was in matters of where I have acted as a presiding judge, and I have found cases have been reported to me of involvement by clerks in accepting bribes, and we have dealt with that case as LMT and escalated it to the judiciary headquarters, and action has been taken against some of those. Yeah.
Thank you. Back to you, Chair.
Thank you, Honorable Chair. Judge, I have a few questions for you.
Yes.
How has the use of technology impacted the work of a judge in Kenya today, both positively and negatively?
I think the COVID situation was God-sent in favor of Kenya judiciary, because we have, at the click of a button, become leading judiciary in matters of employment of ICT. Before 2020, I would say, we were lagging behind in the use of technology. And we would compare ourselves with Ethiopia, who were way ahead. But after the COVID situation came, and judges now and magistrates could do their cases from the office, I think impetus was given to develop facilities and procedures for appearance online. And now many courts, and I think the Court of Appeal is one of those courts, appear and deal with their matters virtually without formal open court sittings. What has that has done is that it has reduced costs for the litigants who have to come to court and are now able to access from their gadgets. And it has also increased the capacity by way of time for the courts to deal with many matters, because you are able to have people attend online without physical activity. It has also improved, and I must say this with the recommendation, that the law reporting aspect of the judiciary has now been developed so much that the judiciary should be thinking of employing AI, artificial intelligence, from the pool of judicial resources at the Kenya National Law Reports. The Kenya National Law Reports, I think, would only be second to South Africa in this library. They are called law information libraries. And I think with the database that we have from the Supreme Court all the way to the magistracy and the other courts, we can have an AI, and our Dr. Kingo is an expert in this, AI research tool which gives us answers from our database, which we have developed and which has been very well developed by the Kenya Law Reports. So I am seeing an opportunity in the use of technology in many ways, both by way of hearings in court and also by the backroom activities by way of research and even judgment preparation in the matters.
Okay. Any negative impact?
Yes, By way of the court proceedings, this is the one that comes to mind immediately. Court proceedings have been watered down. You have seen of situations where advocates will appear in court because online proceedings are court when they are drinking, when they are half-dressed, and without too much care, and without sometimes ability to say who is an advocate and who is not an advocate. Those are shortcomings which I think are properly developed and implemented online appearance regulations may help. But I think the benefits outweigh these problems.
Okay, thank you. You spoke about very passionately about people who are dishonest and people who lack integrity in the judiciary, and that they should be let go.
Yes.
Now, part of the reports that we received, some of the people who described you said that you're one person who does not like dishonest people with a passion. Those people live in our midst. How do you deal with them?
Yes, I have thought about that. We can't kill all of them, but they are part of the society.
Yes.
So what we need to do is that we must make the temptation to be dishonest expensive, so that if we discover that you are dishonest, then we deal with you firmly in accordance with the law. And that will be a lesson to those others who are of like mind. And when this is done over and over, then we shall develop a mental attitude that it doesn't pay to be dishonest.
Okay.
I think the answer is in the consistent zero tolerance and consistent punishment for dishonest conduct.
Okay. Yeah. Thank you, and I wish you the very best, Judge.
Thank you very much.
Yes, Judge, I'll ask you one or two questions. One is, how familiar are you with international and regional legal instruments relevant to your field?
International and legal?
Yes. International and regional
yes.
legal instruments relevant to your field.
Yes.
And what role should developing countries play in shaping global governance norms rather than merely adapting them? Just tie the two questions.
Yes. I would want to say that in matters of constitutional practice, a judge of the High Court must be familiar with the issues of international law, international treaties, conventions that apply by virtue of Article 2 of the Constitution. And also, we also have regional instruments. We have treaties, the East African. We have the African Convention on Human Rights. I don't think that a court which deals with the constitutional matters has a way of avoiding reference. In fact, one of the rules of interpretation is that a court in comparative law, as an Honorable Attorney General had asked, must borrow and see what bearing international and regional instruments have on the work that we are doing, because those international instruments would have been entered into by the country, and therefore they are part of our constitution, and they are relevant in our day-to-day work. Question whether we should have a way of influencing rather than just taking it in as a court, the role of the court in doing that, it is, in my opinion, that by the judicial determinations that we make, by the examinations of these instruments, regional and international, we would be able to identify gaps for improvement and for the improvement and also development where a situation arises. I am giving an example of the East African community, which is the closest home, East African Community Treaty. Although they have the East African Court of Justice, which is not a court of appeal from our courts, but which from time to time has made deliberations and decisions on our situation here. I think that in our engagement with the treaties, the court, in matters that come before them which are relevant, may be able to point out and give recommendations for consideration, yes, for improvement by our, they are called heads of state and government, who will consider what treaties may be involved. I know in some cases protocols are still to be made. Honorable Attorney General, protocol on human rights under the East African Treaty, I think that has not been done. And I think from the court here, our jurisprudence, our engagement with the outside world should be such as we are able to point out the gaps and recommend action by the people who are mandated to do that.
Thank you. Thank you, CJ.
Yes, thank you very much. I think this brings us to the end of the interview.
Yes.
Very robust engagement with you, Judge.
Thank you.
So before we release you, we always give a candidate an opportunity to also engage us. If you want to ask us a question or whatever you want to tell us, the floor is yours.
I would thank the Commission for giving me the opportunity to attend an interview for the Judge of Appeal position. And importantly also, I would commend the judiciary by the procedures of this kind of recruitment, both at this level and elsewhere. It is an achievement which we must be proud of, an achievement which we must keep developing for the benefit of our own future people who come into the judiciary and also for the region. There was a time, CJ, that appointments were made outside this kind of forum, and to see that we have come to a point where judges are interviewed for suitability, I think it is a great thing. It enhances confidence of the members of the public in the judiciary of Kenya, and also internationally, to see that there is a process for appointment of judges. So I think that this is a commendable effort. And for those who are documenting this, I think they should document and share with other judiciaries at the forums of engagement, so that we export our model of judge recruitment to the others.
Thank you. Yeah. We take that commendation well.
Yes.
We are trying to build a strong institution, yes, and to promote the value of accountability, yes, because we do this on behalf of the people of Kenya.
Yes.
I wish you well on behalf of the Commission.
Thank you very much.
Keep up doing the good work. I know you have one initiative that you developed in Mombasa, the Hints of Court.
Yes, that's quite
that it's a good practice that other courts have enumerated.
Yes.
where the judges, the lawyers, and stakeholders engage in the spirit of trying to find out how best we can promote the rule of law and constitutionalism.
Yes.
We commend you also for that.
Thank you very much, Justice.
We will get in touch with you when we complete the process.
Thank you very much.
Give our greetings to the people of Kirinyaga.
I will do that.
Thank you.
Thank you very much, Chief Justice.
ClickUp AI Note Taker is different than all the rest. It allows you to focus on your meetings, not your notes. It captures everything, from action items to key decisions. And after every call, you get a clear summary. But where it really goes to the next level is that it's the only AI note taker that connects your meetings to the rest of your work. So stop stressing about taking notes and get the AI note taker that works for you. Get ClickUp AI Note Taker for your next meeting.
GoDaddy has the perfect hosting plan for any website. From low-cost shared hosting to your own virtual server. Every plan comes with a 99.9% uptime guarantee along with a free domain name and award-winning support. No wonder we're the world's #1 web host. Unlock your online potential today with GoDaddy.
And welcome back to Jeff Quinange live here at Citizen Television. On the bench tonight, it's the firebrands. They may be backbenchers, but I'm telling you, these MPs are outspoken. Kiaro MP Didi Nyoro is in the house, as is Embakasi East Member of Parliament Babu Owino. Gentlemen, let me start with you, Didi.